All right, that was Aditya Thackeray, their brief statement coming in by him. But let me, in fact, welcome Ashutosh Srivastava, Advocate Supreme Court, who's joining us here on the broadcast. Thank you very much for speaking to us here on Mirror Now. Your own perspective with regard to what we saw play out in the top court. The next hearing is going to be on the 11th of July. So obviously there is quite a bit of time in the middle. Meanwhile, we've seen that the rebel MLAs have taken away support from the MVA government itself. How do you really seeing this play out outside court here?
See, as we know that the existing Shiv Sena had filed a petition before the deputy registrar and asking these rebel MLAs to be expelled, to be disqualified. And accordingly, the notices were served by the deputy speaker to all these rebelled MLAs. Now, these rebelled MLAs approached the Supreme Court challenging that notice which was issued by the deputy speaker, considering the ground that it has got no such powers. And secondly, that they already have 2/3 of the elected members of the Legislative Assembly with them. And hence, in that case, the anti-defection law will not apply to them. Now, the Supreme Court was to hear this matter today. Now, considering Article 95 and 180 of the Constitution, when the Speaker is not having the office is not being attended by the Speaker, then in that case, the powers are delegated to the Deputy Speaker. So now, that is one part of it. But the other part that is the most crucial is that under Clause 4 of the 10th Schedule of the Constitution, that if 2/3 of the MLAs have left the party, whether they are forming another party or they are getting merged with another party, so in that case, the anti-defection laws will not apply. And this is what was heard by the Supreme Court today. And accordingly, Supreme Court found that there is some merit in the case which requires to be heard in details at length. And the court was of the opinion that the notice can be served to them. And accordingly, the next date of hearing is 11th July. So it is something like we can say that yes, Supreme Court has found some merit in the case to be heard, but however, it is not decided the matter unless and until the other side of the is also not properly heard. And hence the notices have been served to the deputy speaker and also to the existing Shiv Sena, so that they can also file their affidavit, they can file their reply. And based on the arguments of both the sides, then the Supreme Court may reach to some conclusion on this.
Yes, absolutely. And the other part, of course, is with respect to any precedents. Of course, we have seen several cases like this reach court and reach the legal battle. But with respect to the disqualification, with respect to the powers of the deputy speaker, what kind of precedents are we looking at?
See, one thing is that under Article 163, the governor has got the powers to have the floor test. So that is the another part of this. Because there is no any petition being filed or there is no stay or any kind of order being passed by the Supreme Court in this regard. So now it is interesting to see as to how Article 163, whether it is being utilized by the governor or not to have the floor test. If the governor feels that there should be a floor test, then what happens in that case? If 37 or more MLAs, that is the 2/3 of the rebelled MLAs, if they are not voting in favor of the government, whether the government continues or not, and if the numbers are less, then in that case, obviously the government may have the majority. So that will be interesting to see. And whether any other petition is going to be filed in that regard, that till this matter is decided about the disqualification, which is pending on 11th July, whether there should be any stay on the floor test or anything like that. Because if the floor test happens, because disqualification part is another part, but the other part is about whether the government will continue or not. That is the mute question here. So that power has been delegated to the governor under Article 163 of the Constitution. So that needs to be seen as to how these powers, whether whether they are being utilized, or maybe there will be any sort of further litigation to have the stay on such kind of a decision to be taken or not to be taken by the governor. So we'll have to see that part as well.
Right. And now with regard to the flow test, obviously, until and unless the Supreme Court comes up with its decision, that would then be delayed until then?
See, that is what I said, because as of now, I don't have the detailed order with me. But what I understand that there has not been anything pertaining to that which would have been stayed or decided by the Supreme Court at the moment. Now, the Supreme Court has only decided whether the disqualification notice which was served by the Deputy Speaker holds any water legally or not. So that is the question that will be decided by the Supreme Court in due course of time. But what the floor test, that is something, other Article 163 of the Constitution. So now the governor, if there is no stay or anything given by the Supreme Court, depends on him whether he calls for any floor test or not. So that is another issue, because if the governor, as per law, if the governor goes for the floor test, then in that case also this disqualification petition will be pending and can be still decided. So we have seen
interrupting you, we're in fact Aditya Thackeray is speaking at the moment. Let's cut across.
राजकीय गोष्टी सुरू असतात, पुढे मागे होत असतं, राजकीय जे काही निकाल असतील ते येणारच, पण लोकांची काम सतत करत राहणं हा आमचा सेवा धर्म आणि आम्ही करतो. थोडं मला बघू दे, कारण आता मी बीडीडीच्याच आमच्या सर्व लोकांमध्ये आहे. निकाल मला जरा वाचायचे आहेत अजून. कॉन्फिडेंस जीत की तो पूरी है और प्यार भी पूरा है. जो दगेबाजी करते हैं वो कभी जीतते नहीं है, जो भाग के जाते हैं वो कभी जीतते नहीं है. मैं अभी मुझे थोड़ा पढ़ना है, जो भी अभी का निर्णय हो मुझे पढ़ना पड़ेगा.
Making the first statement after the Supreme Court judgment. Here he is saying that he was in a couple of events since morning, especially the event where he is talking now. Hence, he is not aware of the Supreme Court hearing right now. So he's saying that he will just go through the statements made by the Supreme Court and also the judgment made by them, and then make the relevant reaction just on it. And he also says that the lawyers of the party are also on it right now and to give an appropriate answer in the Supreme Court. Overall, he is also of the view that politics in Maharashtra is actually very, very right now, and he wants to say that the politics will always happen. It's always a changing thing, and but the people's work, the developmental work, should not stop, because of which the portfolios have been changed by the Sena leader Uddhav Thackeray and the Chief Minister of Maharashtra Uddhav Thackeray. Aditya Thackeray here is saying that the people, the ministers, the rebel MLAs who are still at Guwahati have time to come back, and he is not seeing this court judgment as a setback to the party.
For getting us those details and for translating what Aditya Thackeray said at this point in time. Let me in fact go back to Ashutosh Srivastav. Thank you so much for standing by. Yes, please go ahead. So at this point in time, there seems to be a lot of parts which still don't have enough clarity about what could be the possible, ways that this could further unfold.
Yes, supposing now the governor has received a letter for conducting the no confidence motion on the floor. Now, if the governor decides any date or passes any sort of such directions to have the floor test, I think the present ruling Shiv Sena might go again to the Supreme Court and may ask for some stay on these kind of decisions, as the disqualification petition is pending before the Supreme Court. So there could be, I think, a lot of other petitions which might be moved in due course of time, looking at the different angles of the issues being raised. So at present, the issue is about, one is the disqualification, and the second part is whether the government is having the majority on the floor or not. Now, for the disqualification part, since the Shinde group has gone to the Supreme Court and the notice has been served, but the other part, if we see, there is no such order or any petition pending in any court. So the governor, as of now, is not having any restriction or any sort of boundary or stay to have his decision under Article 163 whether to conduct any floor test or not. So that we need to see if what kind of decision is going to be taken by the governor on the letter being received about the no confidence motion, because that is very, very important. And if the governor goes for any such kind of no confidence motion, then what happens to the disqualified? These are not even disqualified. The notices have been only served for the disqualification. So whether they will have the rights to have the vote in favor of any of the party, or they will simply abstain from voting in that case. So we'll have to just watch and see what kind of decision is going to be taken by the governor in this regard.
Absolutely. All right, Ashutosh Srivastava, thank you so much for joining us and weighing in and giving us perspective into the entire legal battle at this point in time.